Illuminating Hope, a podcast of Hope House, brings you Voices of Justice, a series of podcasts where law enforcement officials, judges, and advocates come together to unravel the entangled web of domestic violence. Join us as we dive into the complex challenges faced by those on the front lines of justice, exploring real-life stories, legal nuances, and the human side of these cases. In each episode, our guests share their experiences, insights, and perspectives, shedding light on the multifaceted nature of domestic violence. Tune in for a compelling journey into the criminal justice system, where compassion meets the pursuit of truth and where professionals strive to bring justice to those affected by the cycle of abuse. I'm your host, Tina Johnson, Community Partnership Manager, alongside my co-host, Marianne Matheny, CEO of Hope House, Eileen Sheehan, COO of Hope House, and Randa Hager, Director of Outreach Services. Welcome to Illuminating Hope, a podcast of Hope House. Judge Sill-Rogers was appointed to the Jackson County Circuit Court 16th Judicial Circuit in September 1993. She obtained a Bachelor of Arts degree in Administration of Justice from the University of Missouri, Kansas City. She obtained her law degree from George Washington University National Law Center. Her judicial assignment since her appointment was handling a domestic docket in family court. She is a member of the Missouri Bar and the Kansas City Metropolitan Bar Association and the Association of Women Lawyers of Greater Kansas City. She served as a member and of the board, past president of Operation Breakthrough, president of Lawyers Encouraging Academic Performance, a core team of leaders in Jackson County Safe Family Coalition, and was the founding president of the Kansas City Youth Court. She received the Kansas City Metropolitan Bar Foundation Award for Community Service. Additionally, she received an award from the Daily Record in 2006 as the Legal Leader of the Year. Today we have a special guest with us. Her name is Judge Sill-Rogers, and we're so excited that you're here. You're alongside with your husband, Charlie Rogers, and we have a special co-host today, Eileen Sheehan, who is our COO of Hope House. So, Judge Sill-Rogers, I would love to know the history behind domestic violence within the court system during your tenure.
Well, during my lifetime, in the beginning, my father was violent in our home. And so the first time that I experienced violence towards me and my mother, I was 8 years old. And in the summer when my parents finally separated because my mom got permission from the church to file for a divorce, we had to go into hiding because he actually threatened to shoot us and kill us. So no services available at the time, and we hid out on a farm in North Kansas City with some dear friends with whom my mother worked. That was the taste of it in my family. And years, literally decades went by before I ever thought about that experience again. Because when it was over, it was such a relief to live in peace. And so next, I went to law school at George Washington University in D.C. It's a really good law school. I started in 79 and ended in 82. No training whatsoever, no mention whatsoever of domestic violence as a public health problem or a public safety problem, just not touched on. And so my first experience with a domestic violence victim was when I worked at a private law firm as their pro bono associate. So I represented poor people for a wealthy law firm. And one of our secretaries, her boyfriend viciously assaulted her, dragged her down a driveway. She got a lot of road rash and stuff in her back and her legs. And one of our partners asked me to go to municipal court with her because her boyfriend was charged with city ordinance violations.
So it wasn't called domestic violence at this point.
There was domestic violence as a remedy, but where she wanted someone to stand with her was in the court next to him as he was being prosecuted for what she described he had done. And there were photographs of her physical injuries. The judge was a woman, and the defendant said, but she scratched me. The finding at the end of the thing was, oh, so you were both violent and you're not guilty, sir. I was stunned by that. You're not entitled as a victim in a criminal case. You're not entitled to your own legal representation. It's the prosecutor's duty to present the evidence that will or won't protect you. And so she would not let me stand by the woman. She wouldn't let me sit at the counsel table. I think I had to go back and sit in the front row while I watched her go through what happened. And then I represented a woman in the juvenile division who had suffered unbelievable domestic violence. He would put her on the floor. He would kick her. He lacerated her liver. They had a house full of children. He would make their oldest daughter sleep with him while she slept on the floor. So he was sexually abusing their oldest daughter for quite a long time. She repeatedly went back to him. I did her divorce. It was the first divorce that I ever did. And what ended up happening is I helped her get her children back. And of course, he was not supposed to be anywhere near any of them. One of the things he did for his children for punishment was urinate on them. That's how sad it was. And so one day, the caseworker from the children's division went by, and wasn't he there parked in the driveway? And so then she called me and said, I told on myself. Aren't you proud of me? And to be honest, what I did was I didn't say why, but I asked to withdraw from the case because I just couldn't stay. I didn't trust her to continue to try to protect herself or her children. That was my second taste of domestic violence. Then, in 1993, I applied to be appointed as an associate circuit judge in Jackson County. And one of the things that I would be responsible for immediately was the domestic violence docket. I had zero experience on that docket and zero training. To give you an idea of, except for life experiences, what I had with me when I walked in. And so the people who taught me the most right away were the clerks that helped the domestic violence victims fill out their pro se forms. Because in the statute, the legislature required the clerks of the court, they required the Supreme Court to develop forms, uniform forms to be used throughout the state. And they required clerks of the court to help the victims fill out the forms to be filed with the court. Missouri passed its first domestic violence statute in 1980, and we were the 43rd state in the country to provide that remedy. And it was a pretty meager statute. In order to get it, you had to prove that you were physically harmed or you were threatened with physical harm. And I'm not sure of what all the remedies available to the victim were at that time. The statute was amended in 1986, and in 1986 it was beefed up quite a bit. The act expanded to the conduct from which the respondent was prohibited to perpetrate. And so the act was expanded to add coercion. In other words, the respondent could force you to do something that you didn't want to do or prevent you from something that you needed to do. Sexual assault, unlawful imprisonment, not permit you to leave the home or wherever you were, and then stalking and harassment. The parties who could file the petition included people who were current or former spouses, people who had a child in common regardless of whether they were married or had ever lived together, an adult who was in a continuing romantic, intimate relationship with the petitioner, or an adult who stalked or harassed her. In 1980, when the statute passed, the original judges who heard these petitions were mostly, frankly, men who had fought in World War II, came home, went to law school, and wanted to be lawyers and eventually became judges. And they were, of course, the salt of the earth in our country, saved the world for democracy. But their attitude about domestic violence in general was, why don't we just get her brothers together and go beat that guy up? This is a family matter. Why would the court ever need to be, this is just too personal. Why would the court ever need to be involved in anything like that? And they were shocked that the act gave the court the power to remove a man from his home. All victims are not female, but the vast majority of them are.
Yeah, there's a high percentage.
And that you could remove a person from their home. They just didn't want to do it. Another remedy that they hated was this responsibility of establishing custody and visitation. Even by the time I left, there were judges in the state of Missouri, some places, who refused to do anything but enter a restraining order for you. But they wouldn't take up any of the other issues that would protect your family, especially custody and visitation, because if you don't resolve those issues, the parties have to talk. Because if you think you ticked somebody off because they didn't get to go back to their home, just tell him he doesn't get to see his little boy for whatever reason. Then you're in deep trouble. In 93 is when I was appointed, and coincidentally in 93, the Missouri legislature created for the first time a statute called the Family Court Act. And in that act, they addressed a lot of unmet needs. And it was the lawyers who lobbied for these changes. It mostly has been lawyers that we have relied on over the years to make the changes that we really needed. There have been a few judges who were interested in influencing legislation, but not always. And so the act required that the adult abuse petitions would be heard by family court judges. And the act required that if you were appointed to serve in family court, that you would serve for 4 years, because there was not a backlog necessarily in domestic violence cases, but in divorces and similarly situated family law disputes in our court, they were only assigned to do those for 6 months, and then it rotated to another judge. So at the time that I got appointed, there were thousands of backlogged cases because they were assigned to people that did not want to do them. Mostly the judges were interested in civil and criminal cases. Family law cases are difficult, and they hated them and they were uncomfortable with them. So the easy thing to do was to grant a continuance, and then you were done with it. So we had that. What my court did at that time was say, how in the world could anybody stomach doing this for 4 years in a row? That's crazy. The act also said if a judge is assigned for 4 years and he or she wants to continue, you should reappoint them to the family court when you're putting out assignments. So our court decided we'll only do 2-year appointments, and then that way we'll always have new judges, and it'll always be the burden on the new judges to do this, and none of us regular guys will ever have to do it again. So I was appointed, and the people, as I said, I learned the most from were the clerks that were doing the docket. Looking through the history to try to think of something to make sense of to talk about today, it was when I remembered that the Violence Against Women's Act, the first federal law, wasn't appointed until 1994, during my first year as a judge. The benefit of VAWA is the amount of financial resources that go into service providers so that there are safe places like Hope House to go, and then all of the services that you provide, the counseling, the supervised visits, helping victims get on their feet, find jobs, if necessary, move away, seek orders of protection, finally get a divorce, find a way to separate yourself from the violence and regain your sense of self-worth. So that's what VAWA did. It was Joe Biden who introduced it first in 1990, and then it was eventually passed in 1994. In 1991, I read, when I was looking at VAWA information, that there were 5,745 women murdered in the United States. 6 out of 10 of those women knew their murderer, and half of those were current or former spouses or boyfriends. So 30% of the murders of women in the United States in 1991 had been victims of violence in their intimate relationships and were murdered as a result. One of the thoughts I have is, and so here we are in 2024 in Kansas City, Missouri. If you want to think of ways to reduce our murder rate, I'm sure many of those victims are domestic violence victims. We have to figure out a way as a community to address this with groups of people coming together to offer what their piece of the pie is, to provide services to the victim and also to the batterers if you want to reduce the murder rate. And a huge part of it is the training of the police officers, because the police officers, my experience was, with some exceptions, that they're real reluctance to want to address these issues. And in the beginning, police officers' focus was their own safety, because they knew if they got caught up in this, they might not see home, which is a totally legitimate concern. But so they needed to be taught the tools to address the domestic violence. And I once had the opportunity to attend all of the training that the police officers in Kansas City get at the Police Academy on domestic violence. And I have to say, it was fabulous the time that I went through it. I spent a week at the academy, and the woman that was doing it was phenomenal. So anyway, back to 1994-ish, I did find a senator in Columbia, Missouri, who I worked on some other project with, who I talked to about things that I thought were wrong or could be improved in the laws, and actually wrote some legislation that he supported and got passed when Mel Carnahan was our governor. One of the things that was stupid to me was that you would get an order of protection, you would get the home in the order of protection, but if you got divorced, the order was completely dissolved, and you didn't have the protection anymore either. And so one of the things that I suggested that passed was, if she gets the home in the divorce, first of all, leave the order of protection in effect no matter what, and if she gets the home in the divorce, then he can't go there while the order's in effect. And then the other thing that I'm the proudest of that I did was for children. When I was a young judge, there was a little girl who was murdered by her mother's boyfriend because she didn't recite her ABCs properly when he was dunking her underwater and holding her. And she had reported this conduct to Children's Division people, police officers, her aunt, doctors at Children's Mercy. pregnancy, and she was ordered back into the home. And the Children's Division was supposed to provide extra special attention, and they never saw her again, and he drowned her. They put her in a bag and took their other children that they had in common and fled to California. And the only way that her murder became known was that they were receiving welfare benefits in the state of California, including for her. And so they eventually demanded to see her when the mom broke down and said what happened. So they had dumped her body somewhere in the desert in Arizona on their way out there. And so what I did for her and other children was she came to the attention of the circuit court on a petition for a child order of protection, which is also part of the adult abuse docket. And her aunt, with whom she was close and confided, had filed a petition. And the court determined that the aunt did not have, which was true, she wasn't her legal guardian or a parent, so she didn't have the legal authority to have brought the petition. The Children's Division testified that they were providing all these extra services to the kid. Probably they weren't. And what the problem that she faced is, this little girl, she didn't have a legal representative. With the help of the senator from Columbia, I drafted a statute that requires the court to appoint a guardian ad litem or a CASA volunteer for a child whenever they enter an ex parte order for the child, so that an investigation will occur. And it puts the duty on the court to provide the paperwork to the guardian ad litem, I think maybe within 24 hours is what I said. This was a huge controversy for rural judges who were very angry at me whenever we had meetings. Where do you think we should get these? And I'd be like, well, if you got a courthouse, you got lawyers. And if you can't find one lawyer to help one little kid, why do you have a courthouse? So that was kind of my position. But so the way around it is, and some judges did this regularly, was just issue a summons and set the matter for a hearing instead of entering an ex parte order, which temporarily moves the respondent away from the child. And then that's how they get over the hump of not appointing a guardian ad litem. But if you don't have a legal representative for the child, you don't know what the child's story is. And the judge who heard the child order is dead now. He could have, instead of dismissing the case, he could have appointed a guardian on his own. But he wasn't a guy that had done much family law. But he also was a prior legislator. Could have appointed a guardian for her, and they would have talked to the police officer, the doctors at Children's Mercy Hospital. I mean, they might have found out before Angel left and he murdered her that services weren't being provided. Guardian ad litem then would file their own petition for the kid, and then you'd have to determine where to put the child. So here's another horrible weakness in the family court system. A juvenile officer can file such an order. The juvenile officer could have filed a petition for an order of protection for this child. They almost never do. I bet there weren't 5 of them filed during the 18 years that I served on the docket. So people drop the ball, and part of it is a turf battle, depending on who was in charge of the juvenile portion of the family court. They didn't want those orders coming down there because they thought they were going to be burdened. I actually, from time to time, when we would get a new juvenile judge, would go to the judge and say, why are we hearing these children's cases downtown court in the middle of these horrible domestic violence cases? These are children. They should be private. They should be protected. Why aren't they being filed here? And one of the things that the child order of protection would have provided is it would give you jurisdiction over a boyfriend, because if he's not a parent, they don't offer services to boyfriends in juvenile court, but it gives you the ability to get him out of the house, and it lifts the burden from the mother because she's probably being beaten up too. It protects her from all that being put on her. We're going to pick him, you're going to pick your kid, what are you going to do? But if the court actually worked together and thought about things in terms of how can we best address these problems in our community, instead of, I don't want that down here, it's going to add too much work, things would have been better, and they certainly would have been better for her. In my kitchen, I have a tin type of the newspaper article that thanked me for getting the guardian ad litem order and other things for children passed that year.
I hired a guardian ad litem. My husband and I went to court for guardianship for a grandchild. And the guardian ad litem, they are so pro-child.
Yes.
She didn't really care about what I had to say. I was interviewed. My husband was interviewed. But she was so thorough, and she was for my granddaughter.
Yes.
And I really appreciated that about the guardian ad litem, even through the guardianship process through the courthouse.
So what did it start looking like when you had some supportive services from the Domestic Violence Agency, court advocates in the courtroom, started seeing them, maybe start attending these meetings?
The services that I relied on the most were, especially from Hope House, was the supervised visitation, so that there could be a safe place for kids to spend time with their dad. And the notes from the visits were really good, and sometimes were offered into evidence for subsequent hearings of perhaps for a divorce or whatever. So that was fabulous. Another thing that happened that was really crucial to pulling the community together was when the United Way formed the group to create the Jackson County Safe Family Coalition. And I was invited because of all the domestic violence work I had done. And well, that was miraculous, because around the table were a judge who did domestic violence work every week of her life. I invited our family court administrative judge because I didn't think if the court was going to cooperate in any way without his support that we would be able to. We had the guy that was the juvenile officer at the time, the family court administrator, the layperson. We had police officers. We had social workers. We had people from hospitals. We had people who addressed domestic violence as a public health issue. We had people from the law school. We had people from the shelters. The work that we did was unbelievable. Our best focus was we drew people together and then we acted together instead of staying in our own little corner of the room and caring only about our piece of the pie. So police officers training greatly improved. And coincidentally, I will say this, the guy that was our administrative family court judge at the time, we went around the room the first day and we introduced ourselves. And I said, I'm Sill-Rogers, and I have a lot of experience in domestic violence hearings in my court. And we got to him and he said, well, all I have to say is I'm nothing like Sill-Rogers because I actually believe in the Constitution. So he was one of those guys that wished back in 1986 that they had been successful in not offering this as a remedy. So we never invited him again and things went well. That's all I can say.
And that was that.
Right. But I had to kind of like be under a radar guy.
What was that like, being a female judge in a domestic
Put down
violence?
in a huge public way. Mm-hmm.
Okay.
And then the other group that I forgot to mention is the people that ran better intervention programs, because those changed lives too. And as soon as that became a remedy, I used it all the time. One thing that was different in the downtown Jackson County Courthouse versus here in Independence is this. We did have some legal aid lawyers who already represented their clients, but we didn't have any domestic violence advocates to pull a person aside and give them advice, listen to their story, and figure out what the safest choices might be for them to make. Also, what came out of the Safe Coalition work is we brought in experts from all of our fields. So we brought in a nurse, Jackie Campbell, from Baltimore, and she is a public health nurse whose specialty is domestic violence as a public health problem and determining the risk of lethality. And so she prepared a questionnaire that could be presented to a victim. And at the end of it, she could say, well, here's your score. And here's your risk of actually being murdered in this relationship. And now she's working on a similar device for people who work with families about the risk of death to the children. Because oftentimes a paramour with whom you've not been married is jealous of your children. And to punish you, they will kill your children. And which is a significant risk. So that was really cool. And then we brought in a police officer who worked with her. And the two of them combined worked out a little business card like thing that police officers can carry in their pocket. And properly trained police officers who view this as a positive can use that document, respond to a domestic violence scene, and then say to the woman, I'm going to ask you a few questions, and then say to the woman, I fear for your safety in your life. I want you to talk to somebody. Hold on a second. They can pull out their cell phone, call an advocate at a shelter, and she can get immediate advice. That is a huge life-saving tool that was born from the work that all of the people in the Jackson County Safe Family Coalition worked on. The most recent thing that I'm excited about, even though it's 18 years too late for me, in that group, we wrote legislation. We wanted to develop a pilot project in Jackson County for domestic violence fatality review board. And we worked really hard at it. We had an attorney general that we thought would be supportive. He came to the law school. We all talked about things we were frustrated with. And, for example, I told him, if my former boyfriend drags me into the woods, binds me with duct tape, beats the crap out of me, and leaves me there for dead, and he gets prosecuted for that, why can't I have a lifetime order of protection? Why should I ever have to be in contact with a person whose goal was to end my life? I'm still frustrated by that. One of the cool things that did develop over time, not because of our work on the coalition, so you can get a full order of protection as an adult. The minimum time period is 180 days, and the maximum is 1 year. And that's renewable for 3 consecutive orders. But here's the problem. Some of the new judges, when they were first, this was during my lifetime on the court, when they were first being assigned, the thing could say something horrible, and you could have found that something horrible happened. But you decided, no, all she was going to get was 180 days. Well, the problem with that is she's got a job, she's got kids, she's got a life. In no time at all, you're turning around and you have have to come back and file a motion to extend the order, take time off of work, got to get service again. What if he hides and you don't get service again? Then it's done. And so I was telling them, just do it for a year, because if she doesn't need it, because what they wanted to do was think of the order of protection as a vehicle to force her to take some kind of action, some kind of permanent action. When, first of all, that's her choice, but second of all, it might not be possible. So don't put the burden back on the one that's already been kicked. So that was a big problem. So I did talk some into doing them for a year. Cool thing that they did, and this was when I was still working, instead of making you come in to file a motion for an extension, there's now a box on the form provided by the Supreme Court that says this order will automatically renew on whatever the date is unless the respondent files a motion for a hearing.
That removes a huge barrier.
Yes. So, you could get 3 years of solid protection. And now it's easy. I mean, if a judge would just take the time to check the box. What I would tell them is, if you don't like doing this in the first place, then why wouldn't you just make it as easy as possible to not have them come back? And that would lower docket control. So let's talk for a minute about the docket. I was on floor 7M in the Jackson County Courthouse. So my office was the only courthouse on that floor. And we were surrounded by 3 doors that went into prosecutors' offices. Pretty tiny little entryway between where the elevators were, my front door, and these prosecutors' offices. And the size of the dockets was enormous. Hundreds of people. And we didn't have, and I don't think we still have in either of the courthouses, but I'd be tickled to death to be wrong. We didn't have a safe place to keep these people separate. Guards might say, because we usually had 2 security guards to help the people in and out of the room. And they would say, okay, respondents on this side, petitioners on this side. Some people filed against each other so they could sit on either side. And the prosecutors were so irritated by the size of the crowd on my floor that they would put signs up in their window that would say, on the day that I had these dockets, don't come in here, we are not the adult abuse office. A couple times I put up a sign in my window that said, don't come in here, we're not the prosecutor's office. Anyway, we did have a good relationship with the prosecutor, so just a crush of human beings coming into that room. So one morning I came in, and this was before I think we started locking the door all the time. So one morning I came in and scooted my way past the outer secretary's thing and went and sat down to have a cup of coffee. The clerks would call my docket, and anybody that needed a continuance got one. And that made the size of the crowd more livable. And so I'm sitting at my desk drinking a cup of coffee. Across the room from me, there's a heavy steel back door that was supposed to be my secret exit in case I was foolish enough to use it, because if I ever did, I'd be right in the middle of that crowd. If I left while they were all still out there, not a good idea. They're drinking my coffee, and all of a sudden, this woman's head is being banged against my back door. It is shaking my back door. This is a description of my relationship with the prosecutor office. First, I called the sheriff's department because they're supposed to have 2 guys out in the hallway controlling the crowd. What ended up happening is the crowd pulled this guy off the woman and held him. And so I called 911, and the police department came and they arrested him. And the sheriffs eventually showed up and they said, why didn't you call us? I said, why weren't you here? And I didn't call you because I thought he was going to bust her head through my back door. So here we are. So here's what happens. This will give you just a little snapshot of what happened to people who came for help to the court. The police took him in. They charged him with a municipal court violation. This happened in a courthouse where he was all ready to be there for a restraining order for beating the snot out of this woman. Was it sent for review to the prosecutor's office? No. It went to municipal court. Guess who bonded out immediately? She left, and he went to her father's house looking for her, and her father was old, and the old man called the prosecutor, and he said, lady, I don't know what to do. He's at my front door. It looks like he's got a gun. He's going to break in here. What am I going to do? She said, I'll call the police. And all of a sudden she heard pow, pow, and the old man picked up the phone. He said, well, I came in, so I had to shoot him. Didn't kill him, stopped him. He could have been in jail. To think that police officers, because the police officers make the determination sometimes about where it goes once they get a guy, to think that you would think that somebody could pound a woman's head against the judge's back door, and what he would get for that was you walk him through over there, and 30 minutes later he's back on the road. It's just shocking.
And that victim, I can imagine her thinking, I am safe nowhere.
Right, and she started living with her dad after he beat her up the first time. So she's out in the world. I don't even know. I mean, did she stay and did I enter her order? I don't know that. I never knew which of the hundreds of people that were there that day. Was she among them or did she flee? And I don't know how physically injured she was. But even if she had not been physically injured but had her head banged against a door, I don't understand how that wasn't treated with the dignity and respect that it should have been.
You wonder if it was a stranger to a stranger encounter, it probably would have been handled differently.
That's what I used to say all the time. I used to say, if this was 2 guys guys sitting at the drug house, and they got in a fight over who got the dope next, and one of them stabbed the other. He would be in jail, but these were women. These were women victims. The worst one I had was a woman and a husband and children. He had horribly beaten her. That was the allegation of the day. In the past, he had attacked her in the hallway of one of their children's schools. So we had the hearing. It was a morning hearing. I finished with them. He was mad at me because he wanted me to give him the son, and I said, no, that's my call, not yours, but I am going to appoint a lawyer to represent your children. As soon as they're ready, deliver their findings, well, I'll have you right back. I heard things, and I looked up and she was still sitting there. So I said, ma'am, why are you still here? And she said, he's looking in your back window. When I walk out the door, he's going to get me. And I said, no, he's not. So I said to the sheriff, I want you to go out there. I want you to walk that man to his car. Then she'll be safe to leave. So they went out, and he said, I'm not leaving. My mom's in the bathroom. They sent somebody eventually in, no mom in the bathroom. They walked into his car. She went to work. At work, he called and threatened her. This is done. You're over. She told her friends what had happened. Of course, that was a violation already of the order. I wish she had called the police. So she decided to leave work early, and there he was in the parking lot waiting for her, where he stabbed her so many times that she ended up in intensive care. This happened on a Thursday. The first judge, which was an associate circuit judge who was assigned to the intake criminal cases, which I did before when I was a judge, set a high bond, and so that was that. So Saturday morning, they do arraignments over there in the criminal building. Guy had an arraignment. A lawyer showed up for him. No notice to the prosecutor. The lawyer said, but he's got a good job and he's never been in trouble. So the judge let him out. So then it goes to the circuit judge for the arraignment there, and he set the bond big again. Then it goes to the trial judge, and they have a bond hearing with the trial judge, and they bring the woman from intensive care to testify about how many times she was stabbed, and he threw her on the ground and tried to run over her with his truck, and he couldn't get the truck in the parking spot, so he kicked her several times and said, are you dead yet? So once again, the lawyer, now the prosecutor was there that time, but they did have an opportunity to question her, and he was present. So his constitutional right, confront and cross-examine the witness, he let him out. The case gets set for trial, and they can't find her. She's not cooperating. The week before the trial, she sent a letter to the trial judge saying, this is just a big misunderstanding. Judge Sill-Rogers, it's just a family matter. Judge Sill-Rogers should have done what she was told. She should have given him my boy. So they went ahead. There were witnesses that witnessed the assault in her parking lot. They testified. They couldn't find her, but they had permission to read her transcript from the bond hearing into evidence. And that's the first time that absent witness DV victim's testimony was ever used. And the reason it was usable is because of the ability to confront and cross-examine. Otherwise, it wouldn't have been usable. So the jury found him guilty. After you get found guilty, the trial court sets a bond while you're for the pre-sentence investigation period. He left him out. The dude did show up for sentencing, and the jury, he got what the jury gave him, which was the maximum. After that, I did her divorce. So, but all along the way, just the iffiness, the opinion is the weakest thing still for the judiciary is there should be mandatory training. They do have some training every year, but it'll be on a limited issue. And as new judges, I did go through new judge training, but it's been so long ago, I really don't remember everything that was covered. But I will just say, if there was domestic violence training, it wasn't something that I ever relied on.
I did a research paper in my public speaking class at Mizzou. It was on family court judges, domestic violence, any kind of continuing education that they had, if domestic violence was a part of it. There's an option for domestic violence training, but it is not mandatory.
Right. And that's what it's always been. We did once when I was a new judge, maybe after I'd been there for about a year, probably when VAWA passed, we did one statewide training that everybody was invited to. They all didn't come. What I was saying is, look, you're the peacemakers here. Blessed are the peacemakers. They shall be called children of God.
Right.
And so why are you so limited in what you're willing to offer? If you have the authority to do custody and visitation, why wouldn't you? Because that just means less time that another judge is going to hear some other horrible thing. It did take a long time to do the things that we did. Now the forms are better, but sometimes the respondent would say that he wanted to get his stuff. So I would have them sit down opposite sides of the room. She would write down what she thought his stuff was. He would write down what he thought his stuff was. I would work it out and then set a time for the police to come and watch him get his stuff. And I would tell the petitioner, get a friend, get your family, box this stuff up, put it on the porch. Cops come by, boom, you're done. But one time I did a training with Eileen's husband, and it was on the impact of domestic domestic violence on children because of the murder of 2 little kids in Kansas City. For my grades at the end of it, I either got an A or an F because the people that hate it are just going to keep hating it. And there's nothing you can do about it. So don't assign that.
Part of this happened when you were on the bench because I rode many times with you to Jefferson City as this was getting worked out. But emergency orders of protection, being able to obtain those after hours and on holidays and weekends. Can you talk to that a little bit?
That was huge. There was a bridge program set up at some of the local hospitals where you could go in there and file something. But eventually the legislature did amend the statute and required the court to offer services 24/7. Now, what that meant was, when I was still a judge, I guess the women filled the petitions out at the police departments or an emergency room, someplace like that, and then they would be transmitted to the juvenile division because that's the only place where we had an overnight employee awake, and they would call us and wake us up and read the petitions to us. We would say what we wanted included in the order. And then the other funny thing is, when I was reading the book, it said, and then they could fax it. Well, who even knows what a fax is?
What is a fax?
Isn't that right?
That is right.
Fax. And so now, they all have their little laptop computers, and they can read it, send it, order it, and it's done. That was huge.
Yeah,
I'm sure that saved lives.
Oh, yeah. A lot of work, though, that went into that.
And that was advocates that pushed for that and lawyers that pushed for that. It wasn't leadership through the judiciary, I'm just going to say. It just wasn't.
Why do you think that is, as much as they see?
Well, in the beginning, it was because everybody's an old World War II tough guy. And then another interesting thing about it is they might not want to be the ones that do it, but they sure would like to tell you how to do it. They never have wanted to have a separate division, like the juvenile division is, where everything could come together in one court.
Can you talk a little bit about what it was like once Hope House obtained the grants to get attorneys?
The first attorney that Hope House got was one of my best lifetime friends, and couldn't have had a better person. What that did, even though we don't have a dedicated family court, is provide legal services to women that they couldn't get anywhere else. The fastest growing family unit in our country and in the world for quite a while has been the unmarried couple with children. The big dilemma there is the state would be happy to nail somebody down as the father of the child and make him pay child support, but nothing else is resolved. And if you can't get that resolved and you're in a relationship where you're experiencing domestic violence, you're stuck. I am really excited about the Fatality Review Board being up and running to see how that benefits us. We brought in a fabulous judge from Kentucky, and he was the head of it in his community. But you could sit down with a group of 50 judges from the state of Missouri, and you would have wide-ranging responses to what he was saying. I don't think there's anything wrong with wanting safety in your own community. And I don't think that makes you an unfair listener to the parties when they come to present the allegations and to defend against them and to offer your own evidence. I didn't enter orders in every case. And I would have parties sometimes that were just in the middle of a stupid argument. And I had this one case where, she said her piece, and I was already rolling my eyes, and then he said, she just wants this, so just go ahead and do it. And I said, no, I'm sorry, you guys are in the middle of an argument. Move to another part of the house. But no, I'm not going to kick him out of the house just because you're mad about something that had nothing to do with danger. We had probably at least 3,000 cases filed every year, and probably more than that when the stalking was added. I heard at least 2,000 a year, so 2,000 times 18 years would be 36,000 cases. Pretty sure I heard more than that. When I first started, I had the docket all day, so it was an 8-hour docket. The guy who let the man out on bond, I went to him and said, which was brave, this is not a fair assignment. There are too many people shoved into this room, and some violence is going to break out in that room. So at least 2 people need to be doing this. They should never be heard in the afternoon, because by the end of the day, if the sheriffs are gone, there's no protection, unless I call 911. And I went there after a particularly late afternoon case. I was really angry. I entered a very detailed order of protection, and we were supposed to send the orders down to the clerk's office, and then they processed it, and then they sent it to the police department. And I was so worried about this case, I walked it over. I'm not even sure who's going to get this, but I work across the street. I entered this order. This family is going to blow up tonight. So here it is. You shouldn't have to worry about things like that.
Well, I think that just kind of speaks to your career on the bench, speaks to what a trailblazer you've been over the years for domestic violence and for children who are in situations. And personally, and for Hope House, can't thank you enough for all the lives that you've saved and the laws that you've changed and the things that you've done in our community to make it a better place.
Back at you, Hope House.
I don't think I could have said it any better. Eileen, trailblazer, 100%. Thank you.
Thank you.
Thank you.
Thank you for listening to Illuminating Hope, a podcast of Hope House. A special thank you to our newest recurring donor, Jasmine. Learn how you can support Hope House and domestic violence survivors by visiting hopehouse.net.